Good morning to everybody. Welcome to the today class. There is a family law, and I am dealing the it's a repetition for the writing the examinations. I am sure that you are hearing me. If you are hearing me, please read what I posted on the screen. Yes, anyone? Unmute and you can read what I put it on the screen, so that I could know that you are hearing me and I am hearing you. Yes, anyone can do the same. Syed Rasul, please unmute and give me the answer whether you are hearing me or not. Because you repeated twice, means you repeated because I could see your thing, Sayyid Rasul twice. So if you are hearing me, then you can say that, sir, we are hearing you, and you can proceed. So that way it gives the green signals to me that, and then I can proceed it. So that's my intention. Yes, anyone?
Morning, sir.
Yes, morning. So that means you are hearing me.
సార్ మీ
Very
క్లాస్
good.
9:30 అన్నారని చెప్పేసి ఎవరు రాలేదు సార్ ఇప్పటి వరకు ఇంకా.
Parvale, no. If one person also there, no matter. I will continue my class. Because
ఫాదర్
yes, doesn't matter. Number is not matter. If one person also get benefit of my class, then I will continue my class. Yes, this is the guardianship which I put it over there on the symbol, and here the guardianship how it can works under Muslim law. So that I will deal the introduction, who is a minor, what is the guardianship, kind of guardianship, illegitimate child, natural or legal guardian, custody of the child, testamentary guardian, and the kinds of the guardian, and the comparison between the Sunni and Shia Law related to the guardian, then the multiple choice questions and the conclusions I made it out. So introduction, let us see that what is there in the introduction. So introduction, children are known as a messenger of God. In other words, we can say the children are the incarnation of God. It is significant to take care and provide the proper nourishment to them for their overall development. It is the first and foremost duty of the parents to fulfill all the basic needs of the child, which lead to a dignified and prosperous life. And today, child is tomorrow's backbone of any nation. Child below the age of 18 years is known as a minor. So minor, that we all see that how the minor, because a minor doesn't have that much thinking power to know what is good and what is wrong to him. So a minor is supposed to have no capacity to protect his or her own interest. Law therefore requires that some adult person must be safeguard the minor's person or the property and do everything on his her behalf, because such a minor is legally incompetent. Because a minor is incompetent, because he could not have that much thinking power to see which is good and which is bad to him. That's why the law will protect the minor. So a person who is authorized on the law to protect the minor, the person here, the person means minor or the property or anything of the minor, is called a guardian. So a guardian may protect the persons, even the guardian, I mean, say child body, the person and the property. Even in the case of the marriage also, the guardian will give the consent, so that we can see the three types of the guardianship would be there. One is the property, one put to the person, and here the person means body, and another is for the relationship, there is a marriage. Under Muslim law, guardians are required for the purpose of the marriage. See, in the marriage I could say the jabar, and in other words we can say the wilayatul nikah. Either you can say Jabar. Suppose if you write in the examination Jabar, naturally the examiner will feel more happy, because there is an equivalent word in the family law, that is the Muslim law. And Wilayatul Nikah. Nikah, everybody knows, because the movie also there is a Nikah. For the protecting the minor's person, or the minor's body of the person, we can say Hizanat. That is called Zinat in another word. So Zina is different again. Zina is illegal intercourse with another man or woman, especially who is married to somebody else, or whether the marriage is not Salmanized also. So he's a person means hizanat, and for protecting the minor's property means wilayatul ulmal. Generally, ulmal will say, the supermadar also will say the mal. So the mal is nothing but the property. That is the Arabic word. So mal open indra kada ani cheptam manamu. So these are the call property is called mal. So that we can say the minor's property wilayatul mal. So guardianship of a minor person means the overall supervision of the minor's temperament. It means that the care and welfare of the kid, together with the liability to take care of it. It is more custody, not mere custody of the kid upon a particular age. Let us learn about the guardianship under the Muslim law. So how the guardianship would be there, why the guardianship be needed. So that is an important factor. And who is a minor? We can say that a minor is this chapter deals with the concept of the guardianship, what it means, the appointment of the guardian and the removal of the guardian. The Urdu term was a child is walad. The Urdu term child is a walad, and I believe that is a plural is aulad. And according to the Holy Quran, if I not be mistaken, yes. And according to the Holy Quran, a walad is belonging to be a baby boy or a baby girl. It doesn't matter if the boy or a girl, because walad, because aulad should be the healthy and prosperous and good. It should be there, irrespective of the sex, whether the male or female. The first one or second one or no one also. Of course, no one is not there because the children are the blessings. They are the incarnation of the God. We can say that they are messenger of the God also in the first sentence that we read. Also, it is specified that be it either since they are the blessings of the person should content and satisfied with whatever the case may be. Moreover, the Holy Quran considers the female infanticide and believes that those who involves in such a crime shall be punished on the day of judgment. Because at the time the female infanticide is there, they feel it is a stigma to them, or it is a they have to bow to the coming son-in-law. With that concept would be there. That's why they would like to kill. Even they want to bury alive the female at the time. So in several other verses of the Quran provides for the acknowledgement of the parentage and guardianship. So in the Quran it is somewhere, but in the ayat the acknowledgement and the parentage and the guardianship also dealt. So according to Islamic law, minority ceases when the boy or the girl attains the puberty, that is called the bulugh. Balugh or bulugh. The spelling is Bulugh in Urdu. And the child can decide to marry and there can be no intervention for the same. So in the Hanafila and Shia Muslims, it is assumed that the child attains the majority of the age of 15 and Privy Council decided one of the case law in the property, one of the case law, the puberty means attaining the age of 15 years. That the Privy Council at the time, it is said to be the Supreme Court before the Free India. And I'm sure that you are hearing me. Is it? If the answer is yes, then you can say, sir, proceed. Yes, Sayyid Rasul. Unmute and give me the answer.
Sir,
Shall, shall I proceed? Say yes. Say, okay, okay. I heard your voice because that is enough for me that you are hearing me. Isn't it? Say yes. Good, good, good. So according to Section 3 of the Indian Majority Act 1875, and someone domiciled in the, yes, mute now mute. When you speak, you unmute. When you, after speaking is over, then you can mute it. So someone domiciled in the Republic of India who is below the age of 18 years are said to be a minor. So who is a minor? Can you tell me, Rasul? Yes, just I want to observe you.
sir,
Who is a minor?
below
Very good, very good. I appreciate. A minor is assumed to be no capacity to protect his her own interest. Law does require that some adult person must be safeguarded the person or property. And to yes, now mute. So once you are given the answer, then mute. Otherwise, I will get the sound. Yes. So a man is assumed to be have no capacity to protect his or her own interests. So law does require that some adult person must be safeguarded the person's minor's person or property, including the event of marriage also, and to do everything on his or her behalf because of such a man is legally incompetent. So let us see that this has been similarly held in the case of the Sayyid Muhaddin versus Khadija Bai. On the other hand, the marriage of a minor child shall be permitted by the parent or the guardian. This power is given to the parents or the guardian because it is expected of them to act in the interest of the child. So there obviously exists a trust relationship between the minor and the child and the parent. But the relationship between the guardian and the child is a fiduciary in nature. This is to ensure that the minor child is not acting unfavorably to his own interest. That is what is meant fiduciary means. Fiduciary means involving a trust, especially with regard to the relationship between the trustee and a beneficiary. For example, the company has a fiduciary duty to shareholders. So a person who is authorized underneath the law to guard the persons or property of a minor is called a guardian. Under Muslim law, guardians are needed for the aim of a wedding. Yes, even a guardian will be needed for the aim of the wedding because the bridegroom is below the age of 18 years, and that is the reason that the consent of the guardian or the father would be needed for protecting the minor persons and protecting the minor's property also. So, what is the guardianship? Then, under Muslim law, guardian is called hizanat, the word of the Arabic origin. They are sometimes taken to the mean that something, but under the Muslim law, these two aspects of the guardianship are different and governed by the different laws. So the guardianship of a child means overall oversight of the kid throughout its minority. So long the minority will be completed over there, then the guardian will take care of it all means either property or body or his wedding also. So father or his executor in his absence, first the father is the natural guardian, but don't mention in the Muslim law mother is the natural guardian. Mother is only the custody of a child. So father or his executor or in his absence the paternal grandfather means father being the natural guardian is in charge of the minor persons. On the opposite hand, custody of the child simply means the physical possession of the custody of the child upon a certain age is with the mother. Although the mother is not the natural guardian of the child under the Muslim law, as I said earlier, she has a right to do the custody of the child until the child attains a specific age. Up to a specific age, only the mother is entitled to hold the child under her custody. Yes, that is the point. But the father or the paternal grandfather encompasses the control over the minor throughout the complete interval of the minority, even after the minority also. The welfare of the child with the father in spite of the desire of the child stay with the mother. So the question is comes over there. So of particular age, the mother will be the held responsible. After the age is crossed over there, the father or the paternal father, grandfather will be held responsible till the majority, and sometimes it will be continued till he knows what is what and what is not. Up to that extent, it will be there. Generally, it is set to the 18 years. When the manhood is completed over there, then it is wish and will that whatever he want, he can do it. So, because the emancipation is given over there after the attaining the majority of the child. So it was observed in the case of the Faznabi, yes, Farzanabi, sorry, Farzanabi, Farzanabi versus Ayub Dadamiya, the Bombay High Court held that there is no doubt that under Muslim law, the father is entitled to the custody of his son. Yes, naturally, the father is entitled to the custody of his son over 7 years of age. If the 7 years of age would be there, then the father is entitled to the custody of a child. Up to the 7 years, then the son or the child would be under the custody of the mother. The court observed that as far as the possible, the ordinary rule of the Muslim law should be adhered to. So, what is the Muslim law rule is there? Up to the 7 years, is the custody of the child with the mother. That the children were above the 7 years old, then the custody will goes to the father. The court also found that the welfare of the minors did not lie in the favor of the residing with your mother. So, another point also will be considered over there as per the child's right are concerned that the welfare of the child is more paramount important factor. That is the international instrument also says those international instruments are domesticated in India, and hence the domestic law will be changed over there. The best interest of the child will be taken into consideration, whether the child would be under the custody of the mother or the better or in the custody of the father, which is the best interest of the child. It can be decided by the court. Of course, the child will not give any such a discretion to know that whether he would like to stay with the mother or the father, because he doesn't have such a capacity to decide which is the best for the child. That's why the court interfere it, and court will make it the custody of the child, whether the father or the mother, irrespective of the age. Yes, the children are expressed to desire to live with their mother. Generally, the tendency would be there, but the court observed that they were not of an age when they could make an intelligent preference. The child can make an intelligent preference. Hence, the court therefore awarded the custody of the child to the father. Here, it is adhered that the child custody should be with the father when the child is above the 7 years of age. Yes, now can you tell me that what age that the child would be the father custody, and what age the child with the mother's custody according to the Muslim law? Yes, anyone can unmute and give you the answer so that I can go further. Yes, anyone can unmute, give me the answer. It gives the sense to me that you are following me. Yes, at least you can say pass on. Anyone can unmute and give me the answer. Pass on or give me the answer.
Mother is children of 2 years and father is 7 years, sir.
Okay, let me make it clear. Is according to the Muslim law is the generally children. I did not say boy or a girl. I say child. A child under the age of the 7 years would be under custody of the mother, and after the 7 years will be go to the custody of the father. But when you say the Shia law is different and Sunni law is different again, when the custody of the child is concerned, the Shia law says about there only 2 years for the boy and 7 years for the girl. But the Sunni law says 7 years for the boy and up to the puberty is the girl. That is keep in the mind. So in Rahiba Khatun versus Sabruja Resta, Yeah, Sabrujanesa AR 1996, Gauhati Code 33. The court held that the mother was not the natural guardian but only a custodian of the child, and she loses the guardianship, the custody of the minor daughter in case of she remarries with another person not related to the child within a private degree of the relationship. Yes, once the child is married over there, automatically the mother will be seized with the custody of the child. Yeah, in the present case, the court granted the certificate of the guardianship to the parental grandmother with regard to the minor's personal property. But here, once the mother is no more, then the paternal grandmother custody would be there, where the child will be under that custody. That is decided in the Rahima Khatun versus Sabrunnesa, that is the AR 1996, Guwahati 33. So now let us see what is the illegitimate child. Our illegitimate child can be also called the extramarital child. That is, in other words, in the harsh word is called bastard. But legally speaking, to the neither of its parents nor it is every sense of the word, that is a filius nullius. That is a filius nullius. That is a Latin, a son of nobody. If the illegitimate child is there, but for the purpose of the securing the due nourishment and support, the Sunni law especially make it out until it has attained the age of 7 years, be left in charge of the mother, even that the illegitimate child also can inherit from the mother side but not the father side, but only it is allowed in the Sunni law. After that, it may make his own election, which the parents it will decide. Suppose if the legitimate child would be there, he can decide it whether he will be the father with the mother. Suppose if they are going to take the child to take care of him or her, it may be leave apart from that altogether. So another case lies that Gohar Begum was a singing woman in the keeping of one Trivedi. So Gohar Begum was a singing woman, and she is a keeping one Trivedi. Means a Trivedi is a either I don't think there is a married, but he kept it over there and living together in the union. Trivedi, a Hindu, she was unmarried Muslim, mother of the natural daughter. Yes, it is clearly mentioned that she was an unmarried Muslim, mother of the natural daughter, and the Anjum is the daughter, and acknowledged by the Trivedi. Trivedi acknowledged that yes, she is my daughter because in our companion only she has given the birth. So Anjum was sent to stay with a friend of her mother, so Najma. So Najma Begum is a very wealthy woman. That's why they said, Gaur Begum, please give your daughter. I will see that I will give a good education to her. So the Anjum was sent to the stay with the friend of her mother, Najma Begum, who later refused to part with her, claiming that she had a great affection for the child and had sufficient means to look after the Anjum. And again, she made it that I don't want to give to you, your Anjum daughter, because you are a singing woman, and moreover, your Trivedi also is not that much a breadwinner, and hence the best interest of the child is there. The Anjum will stay with me because I can give the good education to her and nourishment to her. Also, she will become a backbone of the nation. Also, that she refused to give to the daughter to the Gauhari Begum. It was held by the Supreme Court because Gauhar Begum has filed a case. Then the matter went to the Supreme Court that the mother was an illegitimate daughter, is in Muhammadan law, is entitled to its custody. Even the mother, who is an illegitimate daughter, also is having over there, but she is still holding the right to the custody of the child. And the refuse to restore the child to his mother was illegal detention because here the Najma has taken the plea that the Sanjum is the illegal daughter, and hence I will take the better care of it. But the Supreme Court interfered over there, even though the child is the unmarried mother's daughter, but still the mother is having the right to of the custody, and refusal to restore the child to the mother was illegal detention, and that's why it is not given in the favor of the Najma. It is given in the favor of the yes, in the favor of the Supreme Court gave the in the favor of the whom? Unmute and give me the answer. Yes, anyone? Yes.
Gohar Begum.
Gohar Begum, even though she is a illegal daughter also because the Trivedi is there because he is living with the Trivedi. Even that's the order of the Supreme Court. Anjum was handed over to her mother, that is the Gohar Begum, who is the biological mother. Let us see the Muslim law recognize the following kind of guardianship. How many kinds of guardianship would be there? Generally, when you come across the books as well as in the website, also you will find it a natural or a legal guardian, a testamentary guardian, or guardian appointed by the court, or a statutory guardian, and the de facto guardian. These are the four things that you could observe over there. Then let us see the each one after another. What is the natural or legal guardian? So, natural guardian is the one that encompasses the right to regulate and supervise the activities of a minor. Then, naturally, the father is recognized as the natural guardian of his kid under all the schools of Muslim law. The father's right to act as the guardian of a minor is the independent right and is given to him under the substantial law of the Islam. So, a natural guardian is additionally known as a legal guardian. I repeat. A natural guardian is additionally known as a legal guardian, but within the absence of the father's executor might also act as a legal guardian. The executor could be one who is appointed by the father or grandfather to act as a guardian of the minor kid on his behalf. Thus, the natural guardian of the minor in order of the priority as follows. Yes, let us see. It is given only the Sunni law. The first and foremost is the natural guardian or the legal guardian is father. Okay, very much clear. The next is the father appointed the another person who is said to be the executor of the father. That is the second one in the priority. Then after that, when executor of the father, then goes to the paternal grandfather. That means father's father. Means paternal means father's side. Then after that, the paternal grandfather, then it goes to the executor of the paternal grandfather. This is the hierarchy of the natural guardian in the Sunni law. Under Muslim law, within the absence of the above mentioned persons, no one can be recognized as the natural guardian or a minor. So, if the four persons are not there, then no one can be the natural guardian, recognized as the natural guardian of a minor. So, that was very much clearly written over there. Now, let us see the custody of a child. So, now, of course, one after another, we will come across that so that we can go. So, Pulakkal that is Ajisa Kuti versus Bharat Abdul Samad, the mother of the child committed a suicide. I repeat, the Pulakkal Ajisa Kuti versus Bharat Abdul Samad, the mother of the child committed a suicide, and the child was with the maternal grandmother who was a diabetic patient and dependent on her other daughter. So the mother's mother has taken the custody of the child, but she is a diabetic patient and she also not a independent. She is dependent upon her another daughter. The father later married and got children. So again, the father got married because the daughter father and he got the children also. The court held that the conduct of the remarriage of the father of the child itself is not a ground for rejecting the prayer of the custody. So when the father has got married over there, merely by that one, the father will be taken into custody. Then the court made in this way. The welfare of the child is of the paramount consideration because the mother means suicide mother is a diabetic patient. Moreover, she is dependent upon the another daughter's earning. At that instance, by giving the due respect to the sentiment expressed by the grandmother, because grandmother says, my daughter is anyway died over there. At least I will take care of my daughter. The court was of the view that it is of the welfare of the child is more important factor because she is a diabetic patient. Moreover, she is not a dependent. She is dependent upon the another daughter earning. Hence, welfare of the child that the child be with the father, even though the father is married and having a children with another wife. So, failing father, the custody belongs to other paternal relationship in order of enumerated above. Suppose the father is not there, then the custody belongs to the other paternal relations in order enumerated above. As I said, your father, the executor of the father, then the grandfather with the paternal side, then the paternal grandfather executor. That is the hierarchy would be there. So that is the custody of the child will goes in that manner. It was held that Srimati Aninunisa versus Mukhtar Ahmed and others. This is the one of the case law where a minor aged 10 to 11 years in the custody of his mother and has intelligently exercised his preference to continue stay with her. His custody can't be disturbed and given to his father, though he is the legal guardian of the minor under the personal law. A mere claim to the legal guardian in such a situation will not stand on a higher footing than the claim of the real mother to continue to have the custody of the minor who has remained in her custody or in custody of the mother since the birth of the child. It was further observed that the court, it is true that the father is the natural guardian of his minor son under the Muslim law, but still it is too well established to be disputed to proceeding under section 25 of the Guardian and Wards Act. It is not the guardianship of the minor which is of the importance, but the welfare of the minor which has to be taken into consideration while deciding about the custody of the minor. In another interesting, that means sometimes age is not taken into consideration, even though in the Muslim law also. So the best interest of the child will be taken into consideration, whether the father side is that the child will be the safe or having a good nourishment as well as the good education, including the health aspect also. Whether the mother side is a very good and the best interest of the child, then the court will decide whether the child will be in the custody of the father or child will be in the custody of the mother. So what is the parameter? The best interest of the child. So in another interesting judgment, which the Bombay High Court has given, Abdul Sattar Hussain versus Kudachikar, Abdul Sattar Hussain Kudachikar versus Shahina Abdul Sattar Kudachikar, that is the AR 1996 Bombay 134. it was held that the mother is entitled to the custody of your son aged 5 years, even though the father is earning more than money than the mother. Even the father is a good rich man and a multi-billionaire also, but the child age is 5 years. When the child crosses 7 years, then the court will think about the best interest of the child at the time. So the brief facts of the case as is there. The parties are Sunni Muslims and were married in June 1988. Again, the court also says that whether the mother is having that much money also to take care of the child in all means, with the good health, good education, and good nourishment. So that is also the basic needs of a child to grow, because this child is going to be a backbone of the nation tomorrow. So the parties of the Sunni Muslims were married in June 1988. The father is working as a medical representative, whereas the mother is working in a telecommunication. In 1990, a son was born to them. In 1991, a daughter, another daughter also there. In 1994, the appellant gave a talaq to the respondent in 1995, and he was remarried with another girl. So, an application was filed by the mother in 1994 to claim the custody of her son, alleging that in accordance with the present law applicable to the parties, she was entitled to the custody of her son because the son age is very less than 7 years. The mother complained that the child was snatched from her custody and was illegally detained by the father in his custody. And since the child was below the 7 years of age, as per the Muslim law, it will be added that the child below the 7 years should be in the custody of the mother. She was entitled to the custody of her male child. On the other hand, the father appellant contended that he was able to look after his son, whose welfare was so far with him. While deciding the issue of the custody, the court in this case applied the principle: the paramount consideration is the welfare of the child. I repeat, the paramount consideration is the welfare of the child, and held that though there is no dispute that in accordance with the principle of Muslim law, it is the mother who is entitled to the custody of the male child until he has completed the age of 7 years, but the welfare of the child should also be taken into account. The court further observed that in the case to keep the child in the custody of the mother is also the welfare of the interest of the child. The mother, brother, uncle are not entitled to be the legal guardian of the property of the minor. So the question comes over there. Even though the court feels whether the mother will be the good one, paramount welfare interest of the child or not, they will see. But in some cases, let it be only 2 years passed over there. Later on, the child will go to the anyway the father. So better the motherhood feeling will not be left over there. Up to that extent, the mother would be there. The child would be there under the custody of the mother up to the 7 years. And if they feel it, no, even mother could not feel it that the best interest of the child is not there at the time, the father is entitled to get the child custody, even though the child is below the 7 year age. So the mother, after the mother, brother also comes over there, uncle also comes over there, are not they are not entitled to the legal guardian of the property of the minor. Even the property minor will not, but they may be a custody of the. But generally, mother will take the custody of it. That is generally the procedure will be there. So let us see the another case law. Ghulam Hussain Khudubuddin Manar versus Abdul Rashid Abdul Razak Manar. The 2000 Supreme Court of India has held that the mother of the minor can't be appointed as the legal guardian to accept a gift on his behalf of during the lifetime of the minor's father. So long the mother's father, minor father would be allowed over there, then the mother will not be accepted any gift of minor's father. Suppose the minor's father is no more there, okay, she can accept as a gift because in the absence of the father, but in any case, she will not be a legal guardian. So let us see what is the Shia Law says. Within the absence of the father, only paternal grandfather could act as a legal guardian. Suppose the father is not there, at that instant, the paternal grandfather would act as a legal guardian. In the presence of the paternal grandfather, the father executor has no right to act as a legal guardian of a child. Suppose the father is alive, only father will be the legal guardian. Suppose the father is not alive. At that instant, the grandfather can make it out there. Of course, father is allowed and grandfather is allowed. At that instant, the father could not make the executors of the father when the father is allowed. That is there in the Shia law. I don't know whether I'm making it to understand it or not. At least when you see the screen, you could understand what I said, because father is the natural guardian. Number one. After the father, the grandfather is their natural guardian in the paternal side. Suppose grandfather is alive. At that instance, like in the Sunni law, the father's executor cannot be a next one after the father. That is the clearly says in the Shia law. That means only two. Who are they? Father and father's father, only the legal guardian under the Shia law. That is the whole idea. So let us see what is the testamentary guardian now. So we observe only the legal guardian, the first one, then we see the testamentary guardian, the second kind of the guardianship. The lexically testamentary would mean that by the will. Testamentary means will. Hence, the testamentary guardian is a person who shall be appointed as the guardian of the minor's child. This appointment is carried out by the father of the minor child, and under the circumstances where the father is not allowed, then the paternal grandfather shall have the authority to decide the guardian. Excuse me. This mode of appointment is an alternate mode of the appointment of the testamentary guardian according to the usual practice. What is the practice? The testamentary guardian is appointed by the way of the will, which encloses who shall be the guardian to the minor child in case the natural guardian that the father is not alive. At that instant, the testamentary guardian can also be a non-Muslim person. Yes. Excuse me. Even a testamentary guardian is a non-Muslim person or even a female also. However, specifically under the Shia law, a female can never be a testamentary guardian. Of course, because of the various other reasons, she cannot be a testamentary guardian because there are some restrictions would be there for the female to be a testamentary guardian under the Shia law. So, a Muslim law does not lay down any specific formalities for the appointment of a testamentary guardian. Appointment may be made in writing or orally. In every case, the intention to appoint the testamentary guardian must be clear and unequivocal. Unequivocal means no ambiguity would be there. The testator must have the capacity to make the will at the time when it was executed. Yes, that soundness should be there. The testator, when he is executing a will, this means that the testator should be a measure of the sound mind and the time of the execution of the will, and he should be in a full possession of his senses. He should not be a senile. Yes, what is senile? Anyone can give me the answer? For unmute and give the answer. What is senile? Senile. Yes. Anyone can unmute and give me the answer what is senile, so that at least I could know that whether you are hearing me in a proper way or not. That give the sense to me. Yes, anyone? If not, if you don't know, please say pass on. I will give the answer. Don't waste my time.
Relating to old age, becoming
Relating to the old age is called senile. That is the only thing. At the time, the person doesn't have that much thinking power, or because they will when the age will go over, then the people will become a child. That is the what the people says, and it is a fact also to certain extent. Okay, let us come to the executor of the testamentary guardian is designated variously with the Muslim lawgivers, indicating the position and powers. He is commonly called wali or guardian. So wali also we can say that, guardian also we can say that he is also called amin. Yes, he is a trustee, and he is also termed as a kaim moham, and personal care representative of the testator. So these are all the type of the designated in the Muslim lawgivers indicating the position of the and powers of the commonly called wali. The guardian appointed by the court, that is the above one is the second one which is dealt with the testamentary guardian. The third kind of the guardian is the guardian appointed by the court. On the failure of the natural guardian and the testamentary guardian, the Hazi was entrusted with the power of the appointment of guardian of a Muslim minor. Now the court are empowered to appoint guardian under the Guardians and Wards Act. Before the Guardians and Wards Act, the Hazi would be there who will take care of the child, and he will appoint the guardian by keeping the international instrument, the best interest of the child. They will follow it. Now, after the Guardian and Ward Act in 1890, the High Court also have an inherent jurisdiction to appoint the guardian. By this power is exercised sparingly. The Hindu Minority and the Guardianship Act is also supplementary and not in the derogation of the Guardian and Wards Act. Under the Guardians and Wards Act 1890, the jurisdiction is conferred on the district court. The district court may appoint or declare any person as the guardian whenever it considered necessary in the welfare of the child. In appointing a guardian, the court takes into the consideration various factors, including the age, sex, wishes of the parents, and the personal law of the child. And the welfare of the children is of the paramount consideration. The district court has the power to appoint the declare the guardian in respect of the personal as well as the separate property of the minor. Also, the chartered of High Court have inherent jurisdiction to appoint the guardian of the person as well as the property of the minor children. The guardian appointed by the court is known as a certified guardian also. Now you tell me, what is the rank of a magistrate who deals with the family issues? Yes. Anyone can unmute to give me the answer. If not, they will say pass on. Say pass
Legal
on.
guardian, sir. Legal guardian, sir.
I asked the question. Who will deal the cases? of the family issues in the district court, in addition to the district court, the issues of the family, whose rank would be judge rank, judicial magistrate of first class. Are you following me? Okay, let us come to the point. The power of the power of the certified guardian. What is the power of the certified guardian? Yes, certified guardian is nothing but the guardian appointed by the court. The power of the certified guardians are controlled by the Guardians and Wards Act 1890. There are very few acts which I can perform without the prior permission of the court. In the ultimate analysis, the power and coexistence with the powers of the foreign sovereign, and he may do all those things, though the permission of the court, which the sovereign has the power to do so. A certified guardian from the date of his appointment is under the supervision, guidance, and control of the court. I repeat, a certified guardian is nothing but a guardian appointed with the court. From the date of his appointment is under the supervision, guidance and control of the court. So he cannot take the independent decisions. Of course, he can take the independent decisions when things are such a nature, irreparable loss to the minor would be there at the time. First, he will dispose the property, later on, he will take the permission of the court. So that is the only the thing. So limitation of the guardian appointed by the court. So though the guardian appointed by the court has a full right to take care of the property of the minor, but certain limitations are also prescribed in which the prior permission of the courts are required, which are as follows. What are the limitations? When you want to mortgage the property, you have to take the permission of the court. Transfer by sale, take the permission of the court. Transfer by gift, take the permission of the court. And exchange of the property, take the permission of the court. So permission of such alienation should be given by the court in certain circumstances in case of necessity. Excuse me. So in the necessity comes over there, first he will do the thing, then later he will ask for the permission. Conflict between the Guardianship and Ward Act 1890 and the personal laws. If the provision of the personal law is contrary to the provision of the Guardians and Ward Act 1890, the latter will always supersede the prior one. ఇప్పుడు ఏమర్థమైందండి చెప్పండి, ఇప్పుడు చదివిన స్టేట్మెంట్కి ఎవరైనా. I repeat, if the provision of the personal law is contrary to the provision of the Guardians and Wards Act 1890, the latter will always supersede over the prior one. ఏమర్థమైందండి? ఎవరైనా తెలుగులో చెప్పండి, ఇంగ్లీష్లో చెప్పలేకపోతే. Unmute and give me the answer.
This type of guardian, there is no right to take individual decisions. If he has to take any decision, permission has to take permission from court.
I'm sorry. Anyone? పర్సనల్ లాకి, గార్డియన్స్ అండ్ వార్డ్స్ కి యాక్ట్ కి ఏదైనా కాన్ఫ్లిక్ట్ వచ్చింది అనుకోండి, ఏది ప్రివేల్ అవుతుంది?
పర్సనల్ లా
అది చదవండి సార్, చదివితే మీకే అర్థమవుతుంది.
పర్సనల్ లా.
See, if the provision of the personal law is contrary to the provision of Guardian and Wards Act 1980, the later will always supersede over the prior one. అంటే ఏంటిది? The later అంటే ఏంటిది? లేటర్ ఏంటిది? ఇక్కడ లేటర్ ఏది ఉన్నది? గార్డియన్స్ అండ్ వార్డ్స్ యాక్ట్ 1890 ఉన్నది. విల్ ఆల్వేస్ అంటే ఎప్పుడైనా, సూపర్సీడ్ అంటే ఏంది? ఎక్లిప్స్ అవుతుంది. దేనికైతే ఎక్లిప్స్ అయితే ఓవర్, దేని మీద? ప్రయర్ వన్. ప్రయర్ వన్ ఏంటిది ఇక్కడ చెప్పాలా?
పర్సనల్ లా సార్.
Personal law, it is very much clear. Just I want to test you that whether you are following me or not. So it's a test which I want to make it out. So it's clearly written over there. When the conflict between the personal law is there and the Guardians Ward of Act 1980 is there, which one prevail over which one? That means Guardians and Ward Act 1890 eclipse, supersede, overrule, override the personal law. Okay, let us see the last one is the de facto guardian. Yes, de facto guardian is a person who is neither a legal guardian or a testamentary guardian or a statutory guardian, but he himself assumed the custody of the care of the child. So it is so moto idi. So according to the de facto guardian means that an unauthorized person who, as a matter of fact, has the custody of the person of a minor or his property. A de facto guardian could be a person having no authority for the guardianship over the, under the circumstances, has taken the responsibility to act as the guardian of a minor. అసలు ఎవరైతుంది de facto guardian? జనరల్లీ మదర్స్ మదర్ లేకుంటే మటర్నల్ అంకుల్. వీళ్ళు అరే వీడు ఏం చేస్తాడు, మా అల్లుడు చచ్చిపోతాడు, మరి ఏం చేయలేడు కాబట్టి దే విల్ కమ్ యాజ్ ద de facto guardian. ఈజ్ ఎ మైనర్ ఆఫ్ ఎ చైల్డ్ 12 years of who live with his mother. మైనర్ తో ఉంటాడు. ఓకే. అండ్ ఏ మెటర్నల్ గ్రాండ్ మదర్ మెటర్నల్ గ్రాండ్ మదర్ అంటే మదర్స్ మదర్ అండ్ ఈజ్ గ్రాండ్ మదర్స్ హౌస్. ఎవరి ఇంట్లో ఉంటాడు? గ్రాండ్ మదర్స్ హౌస్ ఉంటారు. ఎవరు ఉంటారు? ఈ చైల్డ్ ఉంటాడు, వాళ్ళ మదర్ ఉంటుంది, వాళ్ళ మదర్స్ ఎవరి ఇంట్లో ఉంటుంది? గ్రాండ్ మదర్స్ హౌస్ ఉంటాడు. ఏస్ మదర్ డై డ్యూ టు ద సివియర్ డిసీజెస్ అండ్ ఏ వాజ్ టేకెన్ టు ద కేర్ ఆఫ్ హిస్ గ్రాండ్ మదర్. వాళ్ళ అమ్మ చనిపోయింది కాబట్టి దెన్ అమ్మమ్మ దగ్గర ఉంటాడు. ఎవరు ఉంటాడు? చైల్డ్ ఉంటాడు. ఏజ్ అంతా 12 years. ఇన్ దిస్ కేస్ ద మెటర్నల్ గ్రాండ్ మదర్ ఆఫ్ ఏ బికమ్స్ ద డిఫాక్టో గార్డియన్ ఆఫ్ ఏ. ఎవరండి ఇప్పుడు డిఫాక్టో గార్డియన్ ఇక్కడ? చెప్పాలా? అన్మ్యూట్ చేసి చెప్పాలా తొందరగా?
మెటర్నల్ గ్రాండ్ మదర్ సార్.
మెటర్నల్ గ్రాండ్ మదర్, మదర్స్ మదర్ గా మ్యాటర్. ఎవరైనా అపాయింట్ చేసిండ్రా అండి?
నో సార్, డిఫాక్టో.
డిఫాక్టో అది, ఇన్ఫాక్ట్ అది. దాన్ని డిఫాక్టో గార్డియన్ అవుతారు. ఎందుకంటే అయ్యో నా బిడ్డనే పోయింది కదా, కనీసం ఏమంటారండి తెలుగులో? మనవాడు అంటారా?
అమ్మమ్మ సార్, అమ్మమ్మ
మనవాడు కొడుకును అమ్మ బిడ్డ కొడుకును
మనవడే అంటారు.
మనవాడు మనవరాలంటే ఫీమేల్ అవుతుంది కదా. ఎస్, మరి అది బిడ్డ కొడుకు అవుతుంది. మరి కొడుకును
నాయనమ్మ
కొడుకేమవుతాడండి? అయ్యా సార్, మదర్ చచ్చిపోయింది, మదర్ ఉన్నది. ఇప్పుడు బిడ్డ కొడుకు ఏమంటారు? మీరు అన్నాడు మనవాడు అన్నాడు, కొడుకునేమన్నా
ముని మనవాడు సార్.
అయ్యా, ఇంత మునివి ఎందుకు పోతాండి? ఉర్దూలో మాత్రం ఏంటంటే కొడుకుని పోతారా అంటాము, బిడ్డ కొడుకునేమో నవాసి అంటాము.
రెండిట్లో ఇక్కడ ఒకటే సార్ మీనింగ్.
మరి అది చెప్పాలా కదా? అంటే మీరు చెప్పాలా కదా అది. Okay, no matter. Just I want to test you whether the people are sleeping or whether people are listening to me lecture. Okay, come to the matter. In Muhammad Amin versus Wakil Ahmad, the Supreme Court held that the de facto guardian has no authority to enter into the family settlement in respect of minors' benefit. Generally, that disputes gani, the selling gani, property gani, lease gani, any other thing, de facto guardian does not have the right to do, but he has to take the consent of the court or somebody else so that they can be made. The removal of the guardianship under the Muslim law. Everything guardianship from Muslim law to remove it. There are certain duties which are imposed by the guardian that is required to be performed by the guardians, and the failure of which the guardian can be removed. The removal is usually taken place in the court. A guardian, whether the de jure or de facto, is removed by the court if it is necessary in the interest of the minor. The court may be, on the application of any person interested, or its own motion also, remove the guardian appointed by or declared by the court, or a guardian appointed by the will or any other instrument also. If anyone is appointed by the guardian, he can be removed over there if he does not fulfill the condition in the Guardians and Ward Act. Yes. So number one, abuse of his trust. Naturally, if the trust is not there, then there is no question of the keeping as a guardian. Edantar kadandi, chene kanchen meste kanchike ever kavali antaru. Antaru andi?
Yes sir.
A lawmaker should not be a lawbreaker. Okay, number two, continue to fail to perform the duties of the trust. Actually, the duties which are given over there for the trust, and if he does not perform such a duty, that he can be removed by the court. Incapacity of the perform his duty. Suppose if he doesn't have the capacity, even that also. Suppose ill treatment or neglect to take proper care of his word. So if he take the ill treatment and neglect, then he can be removed. Continuous disregard of the provision of the Guardians and Ward Act. Suppose the act says something, but he goes contrary to it. At the time also he can be removed over there. The sixth point is conviction of an offense implying the opinion of the court. Suppose that fellow is convicted over there and the defect of the character or defect of the morality or defect of the trust which is unfit for him to be a guardian of the Ward Act. Yes. Number seven, having interest to adverse to the faithful performance of the duties. Suppose if he does not perform the faithful duties, then he can be removed. Ceasing to reside within the local limits of the jurisdiction in the court. Suppose guardian ikkada unnadu anukondi, iga vadu poi Kolkata lo untayi labam endandi, Khammamlo pillagadu unnadu, Kolkata lo vadu unnaru anuko, అది లాభం లేదు. కాబట్టి సీజింగ్ టు రిసైడ్ విత్ ద లోకల్ లిమిట్స్. ఇన్ ద అబ్సెన్స్ ఆఫ్ ది గార్డియన్ ఆఫ్ ది ప్రాపర్టీ, బ్యాంక్రప్టసీ అయినా కానీ, insolvency అయినా కానీ, దట్ పర్సన్ కెనాట్ బి ఏ guardian, then he can be removed by the Guardians and Body Act. By reason of the guardianship of the guardian ceasing to be liable to be the seized under the law with the minor is subject. Of course, if any one of the provision would be their Guardians and Ward Acts will not be applicable. Contrary, if he goes over there, then he can be removed. Thus, it is obvious that the guardian appointed by the court for any sufficient reason be removed. He may be resigned also. Of course, he can be resigned also in case that he does not want to continue. In a fit case, the court is entitled to appoint a person other than the legal guardian if the legal guardian is, in the opinion of the court, unfit for the responsible guardianship. Suppose the court feels that there is a legal guardian also there, but the legal guardian is not capable of performing his duty to take care of the own child. At the time, the court will interfere. He will appoint the guardian by the court. Duty of the guardian, of course, duty to support. Okay, use of the force to defend the minor, duty to file a suit, then duty for arranging a marriage of the ward. Yes, control of the guardian by the court, a right to control the act of the ward, duty of the father to take the charge, duty of the guardian not to use the word property, duty to take the proper care, right to preemption, duty to maintain the proper accounts, and a cession of the authority of the guardianship. Yes, he can also be ceased to be the guardianship under these following: by his death or removed or discharged. Either removal or death, discharge, he can be ceased to be a guardian. The court of the words, assuming the superintendence of the person of the word, suppose the court will also make an interference and they will say that he will be removed over there. By the word ceasing to be a minor. So, after a minor laid on Kondi, then automatically that will cease to be the guardian because he became a major. Of course, minority put the guardian and words act 21 years. In case of the female word, by her marriage husband up to automatically sees. Husband who is not unfit means he is fit to be take care of the child. Means that the lady who is become got married after the age of the majority. In the case of the word where the father is unfit for the guardian, where the person of the word where the father ceasing to be guard, at that instance also he will cease. The power of the guardian of property ceases, of course, that same thing by his death, by the court of the words, and by the word ceasing a minor. So, what is the difference in the Sunni and Shia law, which is clearly given in the table, and you will get it in the other books also. The differences between the. If you want, we can take the screenshot now. Yes, we can screenshot now so that I can make it down. So even down also, yes. So even when you see the YouTube also, you could see the thing. Then in conclusion, what I want to say that the Farzana Bai versus Ayub Dalamiya held that the personal law of the belief of the parties need to be kept in mind the adjudicating the bodies whether they hear a matter of the guardianship. So over all the point, the multiple choice question which I would like to ask you is there. So now you tell me, give the answer. Under Sunni law, failing the mother, the custody of the boy under the age of 7 years belongs to, yes. ఇప్పుడు మొత్తం రామాయణం అంతా విన్న తర్వాత రామాయణం అంతా విన్న తర్వాత రాముని సీతను కావాలని చెప్పొద్దండి, నాకు ఆన్సర్ కావాలి, ఇక్కడ కరెక్ట్ ఆన్సర్ కావాలి. అండర్ సున్నీలా ఫెయిలింగ్ ద మదర్ లేదండి. ద కస్టడీ ఆఫ్ ది బాయ్ అండర్ ద ఏజ్ ఆఫ్ 7 years బిలాంగ్స్ టు ఎవరికి పోతుంది? కస్టడీ ఆఫ్ ది బాయ్ అన్నా నేను, అండర్ ది ఏజ్ ఆఫ్ 7 అన్నా నేను.
అండర్ ది ఏజ్ ఆఫ్ 7 వైఫ్ చనిపోయింది, మరి అప్పుడు ఫాదర్ కే కదా సార్. ఇంకా
కస్టడీ పోదు, లీగల్ గార్డియన్ అంటే నేను నన్ ఆఫ్ దీస్. ఆన్సర్ ఇస్ నన్ ఆఫ్ దీస్. ఓకే. అండర్ షియాలా ఫెయిలింగ్ ద మదర్, ద కస్టడీ ఆఫ్ ది బాయ్ అండర్ ద ఏజ్ ఆఫ్ 7 years బిలాంగ్స్ టు, చెప్పాలా? షియాలాలో చెప్తాను నేను. 7 years లోపల ఉన్నది అనుకోండి, ఫాదర్ అవుతుంది కదండి. చూసారా కరెక్ట్ ఆన్సర్? So with this, I would like to wind up my today's class and thank you very much for patient listening. And the tomorrow class is the next question. What is the next question? Yes, now you tell me. So which question I dealt? Sir, maak dele sir, mere cheppala. Expected question lo ఏ క్వశ్చన్ ఇప్పుడు చేశాను నేను. Yes, I believe it is the 6th question. So tomorrow we will deal the 7th question, which is we not covered. So with this, I would like to take the leave. Thank you very much for the patient listening, and I did not keep them. I thank you.